Call the Board Governance Committee to order. And the first order of business is roll call. Ms. Hopper, please.
Henry Jones.
Here.
Rob Fechner.
Mute, Rob.
Good afternoon.
Thank you. Frank Ruffino for Fiona Ma.
Sorry, hi, this is Matt, Pam. Frank is on a phone call, I believe, so I'm just sitting in for him for the moment. Thank you.
Okay, thank you. Lisa Middleton. Lisa Middleton. Stacy Oliveris.
Here.
Elena Ortega.
Here.
Jason Perez.
Here.
Okay, thank you. The first item, next item on the agenda is approval of the September 15 Board Governance Committee timed agenda. I have a motion. Moved by Mr. Perez,
I second.
second by Ms. Oliveris. Ms. Harper, roll call, please.
Rob Fechner.
Aye.
Matthew Seha for Fiona Ma.
Hi.
Lisa Middleton.
Aye.
Stacy Oliveris.
Aye.
Elena Ortega.
Aye.
Jason Perez.
Aye.
Okay,
President,
thank
I have Jason making the motion and Stacy Oliveris seconding it.
you. Okay. And the item is approved. Okay, thank you. And before I go to Mr. Jacobs for the executive report, I just want to mention that the agenda items today is in response to a number of board members requesting items to be placed on the agenda. And these items are information for discussion at this time. And I also want to mention that in the event there are questions for our Fiduciary Counsel, she will be available, Ms. Ashley Dunning. I've also invited Mr. Franson, who helped develop the board governance policies some time ago, to be available in case there are questions for him. And also asked Mr. Toth from Wellshow Consulting to be available in case there are any questions from him regarding these items. So with that background information, I'll turn it over to Mr. Jacobs.
Very good. Good afternoon. Good afternoon, President Jones and board members. The agenda today consists of 4 substantive board governance items for your consideration. They are set forth in the agenda and, of course, in the materials. Ann Simpson will set the stage for each of them and then turn it over to the committee for your discussion and debate. As President Jones mentioned, also present is Rick Funston, an expert on the governance of public pension funds, and Ashley Dunning, your fiduciary counsel. Ms. Dunning, I should note, is here primarily on item 5A, the proposed change to the board governance policy regarding reporting investigations to the board. But she is available for the other items if you think she can contribute something on those. And with that, I will turn it back to you, President Jones.
Okay, thank you, Mr. Jacobs. So we do have one action item, the approval of the Board Governance Committee meeting minutes. So do we have a motion on that?
So moved.
Moved by Ms. Middleton.
I second.
Second by Ms. Oliveira. The roll call on that, Ms. Hopper.
Rob Fechner.
Aye.
Matthew Seha for Fiona Ma.
Aye.
Lisa Middleton.
Aye.
Stacy Oliveris.
Aye.
Elena Ortega.
Aye.
Jason Perez.
Aye.
Mr. President, Lisa Middleton's made the motion, Stacy Oliveris seconded, and I have all ayes.
Okay, thank you, Ms. Harper. Then we go to item 5A, proposed changes to board governance policy, reporting investigations to the board. Ms. Simpson, please. You're muted, Ms. Simpson.
There we go.
Okay.
My apologies. Thank you very much. This item, 5A, has been provided at the request of the board president. And the purpose of this information item is to make clear that under the board's powers reserved, it includes oversight of all activities where the board or a committee has delegated. So what you will see in the attached language on page 9 of 25 in the governance policy, you'll see some language which is there for the board to consider. This has been drafted in its broadest possible form as a starting point for the discussion. But to emphasize, this is about clarifying the board's authority, which exists under its policy. The other point to mention in this regard is that in the current practice regarding the board being notified of investigations, the chief executive notifies the board president and the chairs of the committees of any committees, the chairs of any committees which are impacted when an executive member is subject to an investigation. And the full board is notified when that investigation is completed and contains findings. So the purpose of today's discussion is to look at the current practice, consider the language for discussion in the governance policy, which reads as follows. It clarifies that the board retains responsibility to oversee investigations into allegations of misconduct by the Chief Executive Officer, Chief Actuary, Chief Compliance Officer, Chief Financial Officer, Chief Health Director, Chief Investment Officer, Chief Operations Officer, or General Counsel. And furthermore, CalPERS management will inform the full board upon commencement of such an investigation. So this is for the committee's discussion. Thank you, Chair.
Okay. Okay, very good. We have several requests to speak on this. I just one observation before we get into the discussion. I think the way it's worded is rather broad. I think we need some parameters around this to talk about what types of investigations that the board wants to see. With that background, I'll go ahead and call on the first one, Ms. Taylor.
Thank you, Mr. Jones. So I'm going to reiterate what you said, which is I do believe it's overbroad. I think that maybe we should, I mean, I don't know if we want to look at an investigation of misuse of state assets. I don't know if that's something that would go to the level of the board. Do we want to see something that's more meaty, like conflict of interest? Anything that questions the integrity of the person and puts in light the integrity of CalPERS. Misuse of state assets, unfortunately, happens all the time. But I think it's overly broad. And my comments also, I also feel like it's important for good governance. Before I don't know that it's necessary to have the entire board informed at the onset of an investigation. I get the seriousness of whether or not it's a conflict of interest or it's sexual harassment, but say it's an anonymous complaint. And as I understand it, with all state agencies, they have to investigate that. But it could be an anonymous complaint that's really not valid. And does the board want to know right away? And then thereby, you're hurting that person's reputation. So say Teresa Taylor gets a complaint by Jason Perez, who sits next to her at work, and he's accusing her of sexual harassment, but none of that actually ever happened. So we're going to go through the whole investigation to determine whether or not it had merit. And now you've ruined Teresa Taylor's reputation. So, because you've told the entire board, chances are it will get out into the press. I have a problem. I'm very concerned about privacy of a civil servant. And in those investigations, when I have participated as a steward in those investigations are kept incredibly confidential. So I think it's important that we understand if the CEO has informed the appropriate board chairs and the board president, until we have findings, I mean, before we'd even put out those findings, it hit the press. So I think it's important that we take into consideration the employees' privacy rights as well. I just want to make sure that we're taking that into consideration. But at the very bare minimum, I think that we should at least curtail the broadness of this. So that's my comment.
Okay, thank you. Mr. Perez.
Thank you, sir. On the item to be discussed, page 9 of 25, item 18, I don't think that's a broad enough inclusion of personnel. I think we need the deputy CIOs, the MIDs, a lot of things, global fixed income, opportunistic strategies, private equity, real assets. There's a lot of funds available to them at their level to invest in without rising to the CIO level. And I wouldn't mind seeing board members and their designees included in that as well.
Ms. Middleton?
Okay. Thank you, Mr. Chair. I do have a few comments on this. As I read this and using the word oversee, I interpret that personally to be a word that is consistent with the oversight responsibilities of the board. It is not the responsibility, though, of the board, and should not be the responsibility of the board, to manage an investigation. That should be carried out by professionals, and unless the general counsel is the individual that's involved in the investigation, it should be carried out under the direction of the general counsel and of counsel. I think there's some elements that we need to introduce into this language to clarify responsibilities. I also believe that we need to be very clear in this that due process must be followed, that all of these investigations and all of the work in the investigation must be confidential. It must be impartial in terms of how it is carried out. And it has to be carried out without any influence, not any undue influence, without any influence by the part of the board or by the executives of the organization. The individuals entrusted with the responsibility of carrying out investigations of this level of sensitivity must be able to act without any influence whatsoever. In picking up somewhat on the theme of Mr. Perez, I see the reason for identifying specific individuals, and I think that's important because of the level of responsibility that they have. But I would extend this to a notification of the board wherever there is an investigation that would pose significant reputational or operational risk to the organization. And I appreciate that we're going through the process of clarifying this. And as I understand it, and Ms. Simpson talked about the CEO reporting to the president and the appropriate chairs. As I understand it, that is a practice that Ms. Frost has initiated, which I believe is an extremely good practice, but not one that is found within the black and white lettering of our governance policy, and it is one that we should further define in the governance policy. And with that, I'll end my comments and look forward to hearing from my colleagues. Thank you, Mr. Chair.
Thank you, Ms. Milton. We now have Mr. Fechner.
Thank you, Mr. Chair. I just want to add to the comments. I agree with a lot of what's been said, with the inclusion of perhaps even more positions, et cetera. My concern isn't that. My concern is with the fact that until an investigation has been completed, too many people having information can do harm to the individual and to the organization. I think that's why you should consider strongly who you elect as your president, your vice president, and your committee chairs. Because these people, you've been trusted to do this work. So if you don't think that they can do that, then you should reconsider that. But since we put them in place with the knowledge that they're going to be able to continue moving this organization and leading us, we should give them that leniency, that they get that information. There's a direct line of communication between the CEO and the president and or the committee chairs, so that they're all kept apprised. But at the end of the day, until the investigation is complete, I think it needs to stay in that enclosed circle. Once the investigation is complete, no matter what the outcome is, the entire board should be brought in, should be shared the entire investigation with them. Whether it's a false claim or if it's a real claim, you need to have that information. But I think, again, you put a leadership in place for a reason. I think you need to give them the benefit of doing that job. Thank you, Mr. Chair.
Mr. Miller.
Yeah, I would defer to committee members until they've all had a chance to comment. President Jones.
Okay, dokie. Then we have Ms. Oliveris.
Thank you, Mr. Chair. I would like to follow up on Ms. Middleton's comments. I agree with them. In addition, I think we should take a look at the role of the consultants that we have. So in the investment world, consultants have so much influence over the investments we select, manage, and dispose. And if there happens to be an investigation of one of those consultants, I would feel more comfortable if the board had oversight over that, given the very close relationship between consultants and staff. I also think if there are conflicts of interest that are being investigated, that the board should be notified, because those are very material and represent reputational risk.
Okay. Ms. Yee.
Thank you, Mr. Chair. I think there were others ahead of the queue before I was.
They want to let the committee members speak first and not go back.
Oh, I'm not on the committee.
Oh, United, that's right. Okay. Well, I don't see anyone else on the committee that has requested to speak, so I'll go back up to Mr. Miller.
Thank you, Mr. President. I concur with a lot of the comments. I think that it needs to be broader than just those listed executives, but I also think that we need to be mindful of our role in oversight of investigation, and at what point do we have a role in any investigation. And so to me, there needs to be some level of additional detail about what is material, what is substantive, what does the board need to know beyond the president and the relevant committee chairs. How's that determined? And certainly when an investigation gets to the point where there is findings that something is substantiated that could be material, then the board should be informed. But I still think we need to define this more carefully, and it should be a little bit more of a staged deployment where it doesn't just, any investigation at all triggers notification of the entire board, whether the investigation is into something that would not be very meaningful or substantive, whether it may not be something that we even expect to be substantiated. There's just too many factors to just automatically, be notifying the entire board over any kind of allegation or investigation until it's been a little further fleshed out and until there's a little more information to be able to determine what's the appropriate point to inform the entire board.
Thank you, Mr. Miller. Ms. Ortega.
Thank you, Mr. Chair. Similar to the comments Mr. Miller made, I would recommend that we word this in a way that makes it very clear that the investigation that's coming to the board is in fact a complete investigation, an official, formal, whatever the right definition is. I'm not sure at this moment, but in my experience overseeing investigations, there are allegations that you assign an investigator to do some preliminary work to determine if a full investigation is necessary. If you eliminate that kind of preliminary, those investigations that don't make it past that preliminary stage, I think you get away from some of the things that we as a board likely do not want to hear about, which can often just be disputes that are unfounded or misunderstandings that get resolved one way or another. So I would suggest a way to do that and keep those types of issues from coming to the board is to make very clear what we mean by an investigation. So I think that addresses somewhat Ms. Taylor's comments too about it not being too expansive in terms of the number of items that might come to the board. On Mr. Perez's point about expanding the list of staff, I would caution against going too deep into the staff in terms of what the board oversees. And I think of that in terms of the relationship between executive staff and the other employees at CalPERS. So I would think that if a member of the investment team, for example, that's the example that was used, if there were serious allegations against a member of that team, and they raised to that same level of reputational or operational risk, as Ms. Middleton defined it, that we would hear about that from the executive management. So we would hear about that from the chief investment officer, or if it was someone in Mr. Molds' shop, we would hear about that from Mr. Molds and not have those staff level management issues coming to the board. I think that's too much. I don't think that's appropriate in terms of the way the board's oversight of staff is structured. And I would concur with all of Ms. Middleton's comments. Thank you.
So in order to keep this going, I'm going to, now that all of the members except one who has not requested to speak. I'm going to now call on the non-members, and then I'll take another round from the members. So, Ms. Wesley.
Thank you. I just want to, as the representative from the State Personnel Board, I would be remiss if I didn't pipe in here, even though this isn't my committee. I want to caution everyone to remember the rights that the civil service employees have in this discussion. Are we a policy board at CalPERS, or are we an administrative board? Are we a combo of both? Every employee that we're talking about, I believe, and someone can correct me if I'm wrong, is a civil service employee, and they have certain rights. And what concerns me is that we are going to risk their right to privacy based on the fact that we do have, for probably a number of reasons, information that is considered confidential being put forth to the press outside of the walls of CalPERS. So what happens if an employee is investigated for something that turns out to be meritless? Will CalPERS be on the hook for that? Is it their right to privacy that we're now violating because this information is in the public domain and may not have any merit? That's a concern for me. It also affects the CalPERS in general. When something like that goes out into the public and is meritless, then we're giving out the wrong impression that something is wrong with a certain employee's job performance when we find out later it's not. Because just as much as it can be true, it may not be true. And so if we're taking a certain number of employees and applying a new standard to them, and they are civil service, are we creating two sets of employees with two sets of rights? And if we are, I don't know if that is a place on this board where we can make that decision. We hire the CEO. We can, with all due respect, fire the CEO. We elect the board president. We can unelect the board president. But to dive deeply into how the staff is managed and investigations, I think will create a liability for this organization. And so that really does concern me. I have run a large organization before, clearly not as large as CalPERS, but we had many investigations. And we did not provide those investigation results until the investigation was complete, because I answered to a very political board, which is what we have at CalPERS. So if I had made these investigations that were pending without any merit yet, and the investigation was not complete to the board, those board members would have opinions about the investigation, talk within, between themselves, and then also out in public. It was inevitable. And so that's what concerns me, because that was an organization without civil service employees. This is an organization with pretty much all civil service employees. And unless they have their rights intact and they're allowed to appeal any kinds of disciplines along the correct route, then we could end up putting ourselves in a position of being liable for those decisions that we made and those leaks that come out. So on behalf of the SPB, I think this is something that I would not like to see land on our desk if we make a misstep in this conversation. That's it.
Okay, Miss Yee.
Thank you very much, Mr. Chair. I appreciate your placement of this item on the agenda of the Board Governance Committee, and especially since some time has lapsed since the idea was to bring it before the committee. And I would say that, in terms of what's been proposed on page 9 of 25 of the governance policy, I appreciate that it's broad enough so that we can air out all of our concerns here today as well. I want to align myself with the comments of Ms. Ortega, Ms. Wesley, and Ms. Middleton. I do think that one of the things we don't want to do as a result of looking at revising this governance policy is to set up another set of unintended consequences that really aren't going to get to the, I think, the root issue that we were all trying to look at resolving, and that has to do with what this board does with investigations. I do think that the levels of positions that are identified here are appropriate. These are our top executives, and I don't know that. I think there are other mechanisms for really ensuring conduct and appropriate conduct and compliance with some of the positions deeper down into the organization. But I also want to come back as to why we were even talking about this, and it had to do with really the commencement of investigations on training violations. And I know this is being written broadly, but it seems to me if we're going to try to address the issue that was at hand that gave rise to this discussion altogether, that perhaps we could narrow it with respect to just focusing on the commencement of investigations on training violations. However, I would say that the board should be informed not upon commencement of an investigation, and it really depends on the nature of the investigation, as Ms. Ortega really spoke about. We don't want to create unintentionally our own reputational risk as a result of what is shared as far as information. But I think there's a way to narrow this, and also a way to just be sure that we're getting to the root of the issue that brought rise to this particular issue.
Thank you. Okay. Miss Taylor.
Yes, thank you. I do agree with Ms. Ortega, Ms. Wesley, and Ms. Middleton. I will say that deepening this into other classifications does bring a whole bunch of other problems. In civil service, those employees have a right to their own due process hearings and such. So I don't know if they're called Skelly hearings. They are for our rank and file employees, but it becomes really dangerous for us to get involved even down at the MID level. And I just want to make sure the verbiage here that I think we need to be careful of is oversee investigations into allegations. I think the allegations issue is where we're really wrong here. I think we need to make sure, like Ms. Wesley and Ms. Ortega said, that we're looking at a real investigation. If we're first investigating just the allegations, right, then that's not appropriate for the board to know at that point. But if we have determined by the investigation of those allegations that a full investigation needs to take place, at that point, I can understand that we need to inform the board. But again, I do want us to be very, very conscious of due process rights, of civil service rights. So it's really important. I appreciate it. Thank you.
Okay. Mr. Rubalcaba.
Thank you. Thank you. Yes, I also want to speak a little bit to this, and I appreciate you giving me the opportunity to speak to Mr. Johnson on the committee. I would just say that I was looking at the whole purpose of this governance policy is that we have to maintain our we have to be consistent with our fiduciary duties. And the new language, like many have raised, I think it's written. I think it needs to be a little bit more defined. Oversee investigations. We have I think what we need to make sure is, which we do. I think we have a clear we need to have a clear process that does three things. One, it has to safeguard employee rights and due process. It has more important, but also importantly, it has to protect CalPERS interests. And by that, it means institution and its fiduciary duty, and also be respectful of our role, which is not to micromanage. We have executive staff, the CAO, as that everybody reports to. Although although Ben also seems to report to us. But in the third point is we want to make sure it's a timely resolution. So if there's an opportunity for things to be leaked or opportunity for things to be misstated or slow down or interfere with the proper investigation, it might prohibit the timely resolution in an appropriate way. So I would say our role is to, perhaps we do need item number 18 to clearly outline our authority in this area and our role, but we have to be careful that we respect the Chief Executive Office role and the processes in place, not only in our policy, but other places like people have talked about. So that will be my contribution to this discussion. And I'll just listen. Thank you, Mr. Jones.
Okay, thank you. Ms. Olivares?
Thank you, Mr. Chair. I think there's a distinction to be made between protections of civil service workers and concerns about conflicts of interest when it comes to investments and confidentiality. So I understand that civil service employees have protections, and I know that we will do our best to maintain those, as we have. If we are notified of trading violations, for example, those notifications don't have to come with a person's name. We could just be notified of the classification and the potential type of trading violation. It's critical with trading violations that we need to be notified immediately because of the size of CalPERS portfolio. In many cases, CalPERS could be a market maker, and a trade we make could affect numerous institutional investors, and we could see very serious ramifications from unauthorized trades, from conflicts of interest. So I want to make that distinction very clear. And then secondly, I would like us to further review the avoidance of conflicts of interest section, especially 4B, and how we're defining conflict of interest for board members, particularly when it comes to holding investments. Thank you.
Okay, Ms. Brown.
Thank you, Mr. Chair. I want to say I appreciate everyone's comments here today. I do agree with Ms. Ortega about how we don't need to know necessarily when allegations are made, sort of that first initial step when maybe our own legal office looks into the issue and decides there's nothing here or there is some merit here. But once we have determined there's merit and an official investigation has started, I think the full board needs to be informed. And what can happen in these investigations is there can be interference, and investigations can also be stalled. So if we say an investigation has to wait until it's completed, I've been in senior management for a long time, and investigations can be stalled. And I don't want that to happen. And I don't want months to go by before the board is informed. And so I kind of like that idea that we don't need to know necessarily about allegations, but once there's been some confirmation of that there is an issue and we're going to go sort of into the next step, then I think the board needs to be informed. I also agree with Ms. Olivares about trading violations. Typically this board is informed with a little bar chart, little graph. And it doesn't involve, we never know the name, but we also never know the position. And we never know if, except this last time with the violations in March, we did find out that something like 90% were one person, but typically we don't even get that information. And so I do agree with Ms. Olivares that we at least need to know the level of that person, and so we can find out what's really going on. To not have that information means we cannot do our oversight role. And I really think that the full board needs to be informed when there is an investigation, sort of, I'll call it step 2. I don't know what Mr. Ortega called it, but that appears to have happened. An initial investigation is confirmed that there's an issue, and then it moves on. And I think that's when the board should be informed. Thank you.
Okay, Mr. Perez.
Thanks. I'd like to hear Ms. Dunning's opinion and also Wilshire, please.
Okay. Okay, let us finish with the board members, right? I have a couple more requests and then I'll, okay. Ms. Taylor.
I didn't think I was next. Thank you. I appreciate the notification on trading violations. We get that every month. When we know that there's trading violations or if there are trading violations, those are reported to us at board meetings regularly. So now that we have, 6 board meetings a year, those violations do get reported timely. So, and since we're saying we don't need to have names, I don't see the problem with that. So we already get those reports. I don't know that, and I hope we're not losing sight of, there's a couple of things. Good governance, right? We want to make sure we have good governance. And I'd like Ann to opine a little bit on what typical practice of corporate good governance is when it comes to something like this, but also I want us to not lose sight of what's the root issue we're trying to solve here. If we had all known about a conflict of interest, would that have changed the outcome? That's what I just want you all to think about that. Okay, so we all found out about it. Would that have changed the outcome? So that's what I want you all to think about. But and if you don't mind, could you give us a little bit on good governance when it comes to this process?
Ms. Simpson.
Thank you, Ms. Taylor. Thank you, Chairman Jones. My understanding of leading practice in this area is that the chief executive would have, through their reporting line to the board, in the normal course of events, would inform the board leadership. So, for example, if this was a company, it would be the board chair or the relevant committee that has oversight. So, for example, if it's a compliance violation, it might be the committee that oversees compliance. But my understanding of normal practice in governance is the current arrangements are pretty closely aligned to that. And obviously it's for this board to decide how it wants to conduct that, but just as a reference point through our work with other bodies on governance. Thank you.
Thank you, Ms. Simpson. Ms. Middleton?
Thank you, Mr. Chair. I would like to hear from Ms. Dunning regarding any recommendations that she might have regarding good practices in this area.
Right. Okay. I do have one more request from a board member, then we'll move to the Dunning and also Wilshire. Ms. Yee.
Thank you, Mr. Chair. As I'm listening to everyone's comments, I mean, in some ways, I'm thinking about how I hope we're spending more time on this issue than the actual incidences of problematic situations arising. So I would like to think that these are going to be rare types of activities. And so to that extent, and I think this really came up when Ms. Brown was speaking, that I would like to see the provision narrowed, whether it's trading violations, conflict of interest, fraud, potential criminal activity as it relates to the top executives. I think that is one way of trying to narrow the scope of this particular revision. But to the extent that these instances, I hope, are rare, and with respect to our, and I'm just thinking about the accountability of this board, I certainly would want to be notified as a member of the board, and not for anything else, but to know that this is a potential issue with respect to our top executives, and however that gets communicated. But I just think these are going to be rare instances, and so in some ways we're kind of solving to a lot of perceived hypotheticals. But I hope that I don't foresee that we're going to be facing situations like this very often, or I hope we don't. But certainly narrowing it down to those types of activities of misconduct and looking at, I think full board, notifying the full board. I think it's going to be a rare situation, and I would like to, at least from an accountability standpoint, have the full board be notified in those rare, narrow instances.
Okay, thank you. I'm going to now, I guess, Mr. Jacobs, can we get Mr. Wilshire and also Ms. Dunning into the loop?
Yes, I believe that Ms. Dunning at least is ready to address the group. There she is.
Ms. Dunning?
Yes, I'm here. Good afternoon. Can you hear me?
Yes, we can.
All right. Thank you, Mr. Chair and members of the committee. The committee has had a good discussion so far of the various considerations that should inform you on this topic. From a fiduciary duty perspective, this implicates your duty of prudence. As a prudent fiduciary, you are to oversee the system in a way that you are able to make responsible decisions that are within your authority. You also are to prudently delegate that responsibility where it is more appropriately performed by others. And I think both of those principles have a role to be considered here. With respect to the delegation point, it is very common, and I think strong fiduciary practice, to delegate to your senior executive, your CEO, and your general counsel, the basic oversight responsibility with respect to investigations. It is also prudent and good governance for your CEO and your general counsel to report to those whom the board has or committee have determined are their leaders on a particular topic so that they are fully informed of matters of organizational importance. So the way that CalPERS currently has been operating, I believe, is a prudent one, that your president and the chairs of the appropriate committees are informed of the allegations to let the investigation proceed in a manner that is most fair to those who are being investigated, and that is most likely to preserve the confidentiality of those investigations. I also fully appreciate that as fiduciaries, you do not want to be surprised by matters that are of organizational importance. And that is where judgment calls need to be made about what is reported, to whom it's reported, how it's reported. And I'm afraid that one size will not fit all in terms of the language that one comes up with for this type of a policy. The committee is making clear, and the board is making clear through this most recent experience, that it was not acceptable to you to not have known about this given how these circumstances evolved. But I don't know that that was a given in light of the particulars of what was being investigated here. So what I'd say in terms of the language, if you do wish to specify more directly how the topic of investigations is to be relayed to the board, that you consider a point that a number of committee members and others have mentioned here, which is perhaps only those formal investigations, perhaps even those that are performed by, say, an outside investigator, as opposed to a more informal internal investigation process you may have at CalPERS, would be ones that would be reported to the board. Perhaps you would limit the types of topics that are being investigated to ones that raise questions of operational and organizational risk, although the concern there is that I think it's in the eyes of the beholder what becomes an organizational risk. So I'm not sure that you can come up with language that satisfies that desire. And that it be fully clear in the, be very clear in the context of these communications to the full board of an investigation, that you are not the investigators, that the process is ongoing and must be done fairly in a way that does not result in pressure that would influence the outcome. And as with your other confidential communications, it may not be shared with others. So if you can satisfy those various prongs to make sure that you are engaging in a prudent process in terms of demanding additional oversight, but also respecting the fact that there are reasons why typically these sorts of matters are delegated, then perhaps a fiduciary, it would be an appropriate fiduciary step to include that language in your governance policy. But as Ann Simpson said, I think a strong practice is to typically operate through your chosen leaders with respect to these sorts of matters. And so you are not violating, in my view, any level of prudence or required prudence by having operated the way you have. But again, as I said, a prudent fiduciary also may wish to insist on more reporting of these sorts of matters. I'm happy to respond to specific questions.
Okay. Okay, thank you, Ms. Dunnan. Why don't we go ahead and, while we are hearing from our consultants and counsel, Mr. Toth, are you there?
Yes, sir, I am.
Okay.
Can you hear me?
Yes, we can. And also, is Mr. Funson available, Matt?
I do not see him on the panel here.
I am here.
Okay, good.
There
okay.
you go.
Okay, thank you. Okay, go ahead, Tom.
Henry?
Yes.
It looks
yes.
like Jason wanted to comment before Ashley talked. I don't know if he still does.
Okay, Jason had asked for Wiltshire also, so I'm going down the list, trying to. Do you want to talk now, Jason, or you want to wait until afterwards?
I have specific questions for Ms. Dunning, if that's all right.
So okay, go ahead then.
So something happens, something pops off, the executives are made aware of it, and the committee or the leadership of the board is made aware of it. Does that identify the rest of the board if something is found afoul during that time?
I'm sorry, does the fact that you were apprised of it indemnify? No. I'm sorry.
It's, other than the three board leadership people that are informed of something, are we, the rest of us, are we indemnified? Are we off scot-free?
You are all, you all have fiduciary responsibilities on the board. You are co-fiduciaries in that you are responsible as individuals and as part of the collective. Typically, actions that are taken within the course and scope of your responsibilities on the board are well protected under California law in terms of your discretionary authority to exercise judgment in terms of both how you've delegated matters and how you've overseen them. I would never be one to say that there's no risk with respect to any course of action in the important roles that you all have on this board. But I think that the various courses of action that have been discussed here all have a level of risk associated with them. I think none of you who are exercising good faith in the course and scope of your responsibilities as trustees on the board, who do not have personal financial interests in the operations of the organization, should, under California law, be held liable personally for your actions on the board. You're held liable if you personally have a conflict of interest. You're held liable if you engage in supporting another who has a prohibited conflict of interest. However, what we have here is an allegation of a conflict of interest that I do not understand to rise to the level of creating liability for board members.
So I don't know if I got that answered. Am I off scot-free?
I can't answer that yes or no. I'll tell you if there's a violation of a criminal statute, like a government code section 1090 that I talked with the board about in my fiduciary orientation, that's a whole nother matter in terms of aiding and abetting of 1090 violations. If you're talking about other sorts of allegations into misconduct, it's a different standard. So I cannot give a yes or no answer to that. I'm sorry, Trustee Perez. But I can say that the fact that you have knowledge also doesn't get you off scot-free, because you're not the investigator. So what matters is the integrity of how the organization responds to the topic. Is the organization investigating it properly? Are they delegating the investigation to appropriate professionals who are able to conduct a reasonable investigation? Are they doing so within the parameters of the law? That all matters. That's the process by which you will be judged if somebody challenges the board later.
I will say I am satisfied. And I don't know that happy is the right word, but I'm satisfied and comforted to know that CalPERS took the almost immediate action with the investigation. So that's not an issue. The issue is I guess a little more of a broad issue than, and I need it put in boxes so my brain can understand it. So can't see the whole thing, but if we're charged with trust, if I'm charged as a trustee for this board, that's a huge umbrella. So what takes priority of all that? My priority is to not to CalPERS as an organization, as CalPERS, it's the pension fund, from the way I read the Constitution. So I think that's my first duty, is to protect the fund of the retirees and the members of CalPERS. All the other are subordinate issues, fair representation, and nothing in this document or in our discussions have we said that we're going to violate the employees' rights or that any of those rights are not going to be afforded to them. Simply notification of a higher body is not at all any kind of violation or even an eyebrow raise. So how does that all fit in? What's when we're talking scope and broadly, what is my first duty? Because the Constitution again says plenary, and that's absolute.
It's absolute, subject to your fiduciary obligations and subject to judicial oversight as to your actions. Your primary fiduciary obligation is to the overall best interest of your members and beneficiaries. The rights of your members and beneficiaries are defined by the terms of the plan that you administer, which is why it takes us back to the legal rights of those involved in the matters that you have authority and responsibility over, which is why this is a very complicated topic. When we discuss the rights of your members and beneficiaries, they will have different interests among one another. There are cross-cutting interests of your membership And California law and trust law generally afford you quite a bit of discretion in terms of balancing all of those interests. And that's what you're talking about now in terms of governing the plan in a prudent way. And that is your ultimate goal with respect to this topic of governance. What is the most prudent way from the perspective of those of you on this committee and the board ultimately to govern yourselves? And one aspect of governing yourselves well is in your selection of those to whom you delegate responsibility, which is why I started out with prudent oversight and prudent delegation being sort of twin prongs here that you're managing. So that's how it fits into fiduciary obligation.
So it kind of sounds like to me it boils down to need to know and right to know.
I think that's fair.
And I think all 13 of us fit that category.
I think you all have a right to know. The question is know what, when, how, and from whom. And that is really the rub with respect to this topic. Do you have an obligation to know, or is it potentially more detrimental to your membership if you are all apprised of every single allegation that may be made against those on your senior staff? That's for you to decide.
No, as far as the scope, I agree with everyone on the board where they're saying we need a pretty narrow scope as far as what allegations we're made aware of, but a broader scope and respect all the rest of the members who spoke, and a broader scope as to who's involved in that. But that's fine.
Okay. Okay, thank you. Mr. Tope?
Thanks for the opportunity to comment, Chair Jones. I think I can provide a little bit of context and hopefully also respond to some of the earlier board member questions. First, just a statement. I think that the well-rounded discussion going on right now is a testament to good governance, looking at both sides of the situation and trying to come to a fair framework to deal with multiple types of situations. I think specifically as it relates to the relationship that a vendor or a consultant might have with the board, it's probably useful to get a sense for how we handle this internally for these types of conflicts. Typically, potential conflicts, whether they're conflicts of interest with clients or potential trading violations, which you would find in any potentially find in any financial services firm, those investigations are generally handled by the executive staff. And that could be the chief compliance officer with the legal department and the CEO. There's at least some investigation done to see if there is merit to the complaint or the issue, and then that is subsequently reported up to the board. And I think that tries to straddle both sides of the situation that's been the topic of discussion here of the rights of the employee to a fair and impartial hearing, as well as the right to make sure that the board, who's ultimately responsible for management of the program, or in my case, our organization, isn't surprised. So just a very quick summary, typically investigations handled certainly on a preliminary basis, but could be in the case to a final resolution by the executive staff, and then subsequently provided information to the board. You know, I take the fiduciary duty that we have with CalPERS, really with all our clients, incredibly seriously. And it's our obligation, if there is an investigation of an employee, to make sure not just that our employees know, but also that the financial regulators who oversee our activity also know. And so we have the obligation to report those, and which is subsequently available to all of our clients in our Form ADV. Stop there, see if there are any specific questions I can be helpful with.
Any questions for Mr. Tope? Raise your hand if it is. Mr. Perez.
Tom, here's the difference, though, in the way I look at it. We are not a corporation.
Fair point.
We are a government body. So how do you reconcile that? Or are you saying then no, it's the same? You're just
Mr. Perez, that is an absolutely fair point. I won't attempt to reconcile it because you are correct. There are different governing structures of a corporation relative to CalPERS as a government body. So did not mean to make the two equal, just providing a different perspective for another financial services organization and how we would handle those types of potential conflicts of interest or compliance violations.
Okay, I'm going to now ask Mr. Funson to make any comments that he may have.
Thank you, Mr. Chair, members of the committee. First of all, I'd like to say that I agree with a lot of what has already been said, and I'll try to encapsulate that. Picking up on what Ms. Dunning said, I would perhaps phrase it a little differently, that one size fits one. And I think that's the challenge that you face. I think you face many definitional challenges, as you've said, in terms of the seniority of the personnel being involved, the order of magnitude of the potential infraction, that there should be due process allowed, and with respect to the privacy rights of the individuals involved, and that due process would involve either an internal investigation or, as the board well knows, if there's an external investigation, the board has the right to retain counsel, independent counsel, at any point in time. I gather that the board already does receive compliance or non-compliance reports, which comment on perhaps on the frequency of certain types of incidents and the severity. And I think that that's something that perhaps you could improve possibly in terms of the way those events or incidents are classified while still respecting the rights of the individuals. And I would say that with respect to how this gets reported to the board, certainly that would satisfy the information requirements at a high level while still respecting the rights of the individual. But I would also say that when an investigation of a particular magnitude is underway, our recommendation would be is that it should come to the president of the board and to the chair of the Audit and Risk Committee, as opposed to whichever committee may be affected by the particular infraction, to give consistency to that. Whistleblower, I believe procedures are already reported and coordinated through the Audit and Risk Committee. And I think this would be a more consistent process so that those two chairs, the president and the chair of the Audit and Risk Committee, would be notified when there was a significant material investigation underway. But again, the particulars of that would not have to be known until the due process had been completed, and then it would be appropriate then for the rest of the board to be notified.
Okay, thank you, Mr. Funson. Are there any questions for Mr. Funson? Raise your hand if you do. Seeing none, now I think we're going to have two more questions, and I think we need to then move on to the next agenda item, but we'll have to give some direction. But we have Ms. Wesley.
Thank you. I just want to be clear about one of the things that I had said earlier when we were talking about our liability. What concerns me for this body and for this organization, that should an employee's right to privacy be violated, that employee potentially would have a lawsuit against CalPERS. That is a possibility, and that goes to our role as stewards of this organization. And I feel, based on the information that I have seen from ORIC, that we cannot confirm and feel comfortable that that would not happen. So for that reason, I am concerned about
Ms. Wesley, you should not be commenting on a report that hasn't been discussed in public.
Okay, thank you.
Okay, thank you. I think, Mr. Miller, I think that's the last one. Yeah, and then we do have some public members that are requested to speak on this before we give direction. So, Mr. Miller.
Yeah, thank you, Mr. President. This is for probably for Ms. Dunning, but also Mr. Funston and Mr. Toth may have some opinion, or even Mr. Jacobs. As a fiduciary, when I think about these difficult topics, not to put too fine a point on it, but I also have to think about, my right as a board member to see information versus the risks and liabilities that poses if I and other board members or anything are getting information that implies some of these liabilities, as Ms. Wesley pointed out. Frankly, if I've got a leaky bucket, I should not be dumping more water in it if I don't need to, because I know it's going to leak. And when we have concerns about confidential information that can hurt the integrity of our organizational integrity, the integrity of our processes, perhaps even of an investigation that's ongoing, how do we weigh that against the desire, inquiring minds want to know, and none of us wants to get caught off guard with, a press inquiry or something about something we don't know about. So how do we balance that versus the risk that we make it easier for information to get out of the organization when it shouldn't?
That's an outstanding question, because what it really highlights is the point that each of you as a trustee is a member of a whole who collectively have a fiduciary responsibility relating to your administration of the plan. And to the point that Ms. Wesley made about potential liability of CalPERS, that's different from the question posed by Mr. Perez about the individual liability of each of you individually. I responded to the individual question. I didn't respond to the question of liability of CalPERS, which of course matters to the extent that that means that assets of the retirement system are spent defending privacy-based lawsuits brought against the retirement plan. So you as a board, I recommend that you think about this from an organizational perspective, from a governance perspective, more than thinking about it from your personal interest in knowing. Well, I appreciate that you don't want to be surprised. It's most important as you think about this to think about how the system is going to and how the board is best going to proceed forward with respect to future investigations in the context of future boards who may or may not be able to preserve confidentially as well as you may view yourself being able to do at this time. Very good question. I hope I answered it sufficiently.
Okay, Mr. Miller? Okay, thank you. Okay, Cherie or Mr. Fox, we have a request for members of the public to speak on this item.
Yes, Mr. President, this is Kelly Fox. We do have commenters on item 5A. The first of which is Tim Behrens from CSR.
Thank you, Kelly. President Jones, members of the committee, members of the board, very interesting conversation. I'm sitting here bouncing back and forth as the president of a corporation, wondering how we take care of business like this. A couple of things I would say is I would get rid of the sentence that says board oversees investigation. I don't think the board should have anything to do with the investigation, period. I think that you can identify a narrow scope of the most egregious things that have gone on in CalPERS in the last 20 years, and I think that would be a real short list to give you some guidance in what should be reported to the board members. I like the narrow scope of employees that you listed. I think Ms. Yee is right on. She says she does not anticipate, and as a stakeholder, I don't anticipate several more of these issues to come up in the future. So I would just urge you to keep on talking and come up with the best language that protects the employee as well as protects yourself and CalPERS. Thank you.
Thank you, Mr. Barron.
Mr. President, we have the next speaker is Mr. Al Darby.
Mr. President and board members, committee members, Al Darby, RPEA. My first issue is that related to internal people, anyone across the enterprise who can you, my clock isn't running. Is that the case, or am I not being heard?
We hear you, Mr. Darby.
All right. The clock is now running. All right. Anyone within the enterprise who can award sole source contracts or investments should be clearly within the scope of these investigations. However, recognizing the issues raised by the person from the board member from Ms. Wesley and also Ms. Ortega. But what about your HR department? Don't they handle these civil service employee issues, investigations of allegations of these sorts? I didn't hear anything about the HR department. Also, there wasn't much said about investigations of outside manager and consultant skullduggery. We had some of that in the early 2000s, and it involved the CEO. So there's questions of how you would deal with that particular situation. The outside managers and consultants are not covered by civil service or any other area that could be considered a problem related to civil service. So those are the comments I had to make. Thank you.
Okay, thank you, Mr. Darby.
Mr. President, the next caller is Jerry Fontaine from CSR.
This is Jerry Fontaine from CSR. Can you hear me?
Yes, we can.
Okay, thank you. In listening to the conversations so far, there's a distinct amount of concern having to do with liability, with the rights of employees and things of this nature. And those concerns are genuine concerns. But I believe having the board, even as an informational item, go out on this limb without any assistance with your legal department establishing parameters to work within, it almost appears to me that they will step in once you make an error in judgment, but not before. You need to get advice from your legal department, HR department, prior to sitting down and drafting language having to do with this issue. Thank you.
Thank you, Mr. Fontaine. And by the way, the executive of this committee is our general counsel, Mr. Fontaine. So this legal is apprised of it. Next, anyone else, Mr. Fox?
Yes, on this item, 5A, two more speakers.
Okay.
Mr. Larry Woodson from CSR.
Good afternoon, Larry Woodson, CSR. Thank you for the opportunity to comment, Mr. Chair. And I'd also like to thank Board Member Yee for her perseverance and for her September 2nd letter, which really pushed these 4 issues into discussion, and I appreciate CalPERS allowing them to be discussed. So as Tim's already stated our overall position, just a couple of observations. I think maybe there's one board member that seems to be just maintaining the status quo on this issue. I think stakeholders would strongly oppose that. I think there are ways to fashion the current language, and as Ms. Yee and others have identified, you can get into greater specificity on what misconduct you consider egregious enough to include, and maybe list that. I think also the distinction between preliminary investigation and, yeah, we've got enough evidence to dive into this is important to make. And at that point, I think informing the full board is important. 3 members is really not enough. And I think, and I'm not under the restraint that the board members probably have here to name the situation, which is the abrupt exit and resignation of Mr. Ming. Precipitated a lot of this and the way it was handled. And I think that the additional 10 board members needed to be informed. Certainly there was stuff released to the press that seemed to be very revealing. And of course he has already left, so it's a little different situation. He's not a current employee, but and then lastly, I just point out, which everyone knows, these are executive officers, not subject to civil service rules. So I appreciate if you dive down too deeply in the organization with reporting, you would run into that. But that would not be the case with this level. And I hope that you can fashion something that addresses this and that it's to the whole board. Thank you.
Okay, thank you. Mr. Fox?
Yes, Mr. President, one final speaker on item 5A, Mr. Bijan Mayahar from the Association League of California Cities.
Good afternoon. Good afternoon, President Jones and board and committee members. Bijan Mayahar with the League of California Cities. I'm grateful to speak with all of you about this agenda item. I would say broadly, there are a number of items that you all are looking at both today and tomorrow that deal with transparency and the governance and the relationship between the board and the staff. And I would say from our organization's perspective, we don't necessarily take a position on there being any right or wrong answer for all of you, but we would like to opine that as far as the framework that you all should be using as you evaluate the decisions in your transparency and in your governance decisions, we highly encourage you all to consider what does stability mean in the context of the board. I think, frankly, there's a lot of consternation among my members given the poor performance of the fund as far as the investment returns, and then coupled with the confusion and concern following Mr. Mang's departure. So we strongly encourage you to think really through a stability lens, as was mentioned before you transition to public comment. What do the changes that you all adopt mean for your relationship with your staff? And what do they mean for the stability of future boards to deal with challenges that may be like this and may not be like any of these at all? And so we think those issues we think this is an issue that's worthy of your consideration. We think whether it's the relationship between the CIO and the CEO, that we encourage you all to really just think about how you can provide and demonstrate stability to all stakeholders, whether that's employers, employees, or retirees. And anything that you all need from the employer community, speaking from the city's perspective, we're always happy to partner and share any kind of best practices that we can to ensure that you all are having the best informed discourse you can on how to support the system as a whole, not just for the current generation of employers, employees, and retirees, but for those future generations as well. So thank you very much, Mr. Chair.
Okay, thank you very much for your comments. Okay, Ms. Oliveris had to step away. She's back, and she had a question for Ms. Dunning, and I think who else? Ms. Oliveris?
And Mr. Toth.
Okay, go ahead.
My first question is for Mr. Toth. Mr. Toth, could you talk about how a conflict of interest in terms of personal investment holdings or some disallowed activities or conflicts of interest with consultant firm regarding trades could affect CalPERS and could affect the overall markets, please?
Sure, I'd be happy to provide some general comments. So, specifically as it relates to conflicts of interest between consultants and clients, oftentimes there's discussion about potential opportunities. If whatever that opportunity might be that a client is going forward with or is considering could positively impact the personal holdings of a consultant. They might be so inclined to recommend that opportunity is pushed forward, increasing its value, hence increasing the value of those personal holdings. So, in order to mitigate that, typically there are conflicts of interest disclosures and personal trading policies in place, which require either pre-approval or outright restrictions on the holdings of individual securities, and then in many cases compliance processes in order to monitor and manage the personal holdings of, I can speak specifically to my firm, all of the access persons, as they're called, across the organization.
And what about how trades could potentially affect the market?
So for an investor like CalPERS, with the size of the trades, if a consultant, I'll use that as an example again, has knowledge about potential trades within the market, given CalPERS size, to trade in front of those trades and the potential market impact that those trades will ultimately have, that what's called front running would be detrimental to our clients. And certainly a violation of our fiduciary duty. So something that naturally needs to be monitored by compliance.
Who regulates that?
Who regulate within the firm or broader?
Broader, please.
Like the form ADVs and the SEC have regulations, covering the front running of securities for fiduciaries and relative to their clients.
I think that's where it'd be helpful for you to provide a brief overview so that we also understand the liability that we have as an organization if there is front running.
Okay. I'd be happy to provide some additional information.
Thank you. And for Ms. Dunning, I want to understand what role expertise has in terms of how a board or who is notified on a board about incompatible activities, about conflicts of interest. As we look at this particular incident, and hopefully this is just isolated to one incident, this is regarding investment holdings. And I understand as board members, we're supposed to provide our expertise. And I'm wondering how we can do that, do our job if we don't have access to this information, or if we don't understand the nuance of holding these investments and how these trades are made.
So California law defines pretty broadly what constitutes a personal financial interest in a type of asset or property. And if you all think about the statement of economic interests, the Form 700 that you fill out annually, that's where those interests are disclosed. And it's not simply a disclosure obligation. It's not sort of a meaningless act of going through the process of identifying those items. It's disclosure and then determining when it's appropriate to recuse. And that's all tied together. And you have training at CalPERS, and many of us, including myself, file those forms, and they are public. It's all out there. So everyone has a responsibility to fill those out in a timely and accurate way, and to keep track of what that means in terms of their ability to act on certain topics or requirement that they recuse. And if there is a circumstance where now they can't do their job because they'd have to recuse too frequently, that's an appropriate context to no longer have those holdings or put them into a different form. But I think that's what I'd say under California law, that it's not, there's no mystery to this. It's a form that we all fill out that is very broad, that identifies what we're supposed to disclose, and that dictates to, in large part, what we have to be careful about in terms of how we conduct ourselves in our public roles on public retirement boards or advising public retirement boards.
I'm sorry, I think my question was a little bit different. So in terms of the board being notified of a potential violation or of an investigation that is underway regarding investments, and not having that investment expertise, but perhaps others do, I want to understand if there's a duty to understand the nuance behind that and to share that information with someone on the board who has that expertise. For example, let's just say it was a different situation and there's an investigation and it was regarding public benefits. And this notification was made to the board chair and to a committee chair or two, but they didn't know about public benefits. That wasn't their area of expertise, and they might not be familiar with the nuance. That's really critical to understanding the severity of the issue and the implications to the organization. At what point does expertise have a determining role in who is notified and when?
Interesting question. So I think there are two aspects to a complete answer. One is that each of you come to the board with different levels of expertise, and you are to share that with one another. So the fact that some of you maybe have more knowledge and experience with different aspects of CalPERS business, in fact, is in a sense why you're on the board, why you have such a diverse board of membership in terms of where you all come from. But that does not make each of you the expert advisor to the board on those particular subject matters. And that's where it's important that you consult with others who are not board members, who can advise you in the particular area of expertise, whether it's retirement benefits or conflict of interest law or whatever else is implicated, actuarial matters, real estate matters. You may have people who are experts on those on the board, but they are not the actuary for the board. They're not the lawyer for the board. You're to consult with others who are not on the board who are experts in those fields. And that's where if the reporting responsibility is, say, to the president and either to a committee chair for the committee that's implicated by a matter, or as Mr. Funston suggested, the chair of the audit committee, that's when they bring in the experts to advise them. And they should, on what's the applicable law. And if the conclusion for that is that there hasn't been sufficient training for board members or for senior staff, you also can, that's also an appropriate response to provide additional training. But it's not for the board to sort of self-identify who's the expert on the board on this particular topic, and now I'm going to be the one to whom all of these things are reported. That's not an appropriate way to manage the board from my perspective. Although each of you should share with one another in the appropriate context your knowledge base.
Thank you. I appreciate you clearing that up. You mentioned the role of disclosing our conflicts of interest on the FPPC forms and how we're responsible for doing that individually. As Mr. Toth discussed, there are also other regulations that govern conflict of interest, particularly SEC regulations. How do you view board individual holdings or individual holdings by board members in light of those SEC regulations?
There have been circumstances where the SEC has looked at public retirement funds, as I'm sure you're all aware, in terms of insider trading concerns. So you're all subject to all of those laws. This isn't an area where I'm an expert on federal securities law, but most certainly you are all subject to them and may not engage in insider trading, for example, or front running. I'm sorry, I can't give you a more sophisticated answer than that, but that's high level.
Okay,
thank you. And sorry, Chair, who does advise us on that?
Is that a question for me? I think,
or for Chair Jones. Sure.
Maybe your general counsel can advise you.
Okay.
I'm sorry, Ms. Oliver. Who would advise us on what?
On SEC regulations as to conflicts of interest by board members or with board members?
If we had an issue in that regard, we have specialized counsel who we would turn to for that, outside counsel.
But we don't have somebody that's advising the board on that right now, is my understanding. Is that correct?
I'm not aware of any issue in that regard, so yes, that's correct.
Okay, thank you.
Okay, thank you. I think we're gonna now move on. I think this has been a very...
Henry, can I say something real quick?
Okay, if you can make it short, Teresa, go ahead.
It'll be real quick. I just wanted to answer to, I can't remember who it was now that was talking about executive officers not being civil servants. They actually are. The only executive officer at CalPERS that is not is Marcy. And then finally, I think Mr. Toth gave some information about how investments work in his office and who gets pre-clearance and all that stuff. And I think it's important that maybe Marcy or Dan at some point get with Stacy and talk about that, because we have a process, and I swear we just talked about it in investment committee, but I could be wrong. Maybe I'm thinking of something else. But there is a very fulsome process with our I-Corps and our compliance folks before we can sign deals. Yeah. So I want to make sure that everybody's aware of that. Maybe we can share that with the entire board.
Okay, so be it. Okay, I think listening to the discussion, I think unless anybody have a different viewpoint, I think that the next step is to have the CEO come back with pared down policy around this area. And also, I would suggest that we get input from State Personnel Board and CalHR on the language that we could use to address the concerns of not violating any rights of our employees, since we do know that all of our employees are civil service except the CEO. And so we want to be sure that whatever language that is going to be discussed next time, it has the opportunity to have that view. But I think what I heard is that and also I think it's a good suggestion about adding the chair of the audit committee to bring that person or that position into the process, Ms. Frost, when you develop the new guidelines that come back to us. And so I didn't hear anyone wanting to remove any of the other affected chairs, but also to add the chair of the audit committee and bring back a pared down suggested to us that, and I think what I heard is that information may be shared if an investigation is initiated, but not who or what. I don't know how we characterize that in a written statement, because as soon as you send someone something, say an investigation started, and the next question is what. So we need to be very careful on what we allude to in terms of that investigation. So if that's enough direction, Ms. Frost and Mr. Jacobs, I think that we will move on to the next item. Let me hear from Mr. Jacobs and Ms. Frost first.
Yeah, I think that's sufficient guidance. I think what we will do is bring back some options.
Okay.
And I don't know that I heard any agreement on any particular thing, but I heard a lot of different things with respect to some specific items like the breadth, who it ought to apply to, the type of investigation, and the particular time during the investigation at which more members should be informed. So we'll bring you back some options for each of those different factors, and I think it would require some further discussion on behalf of the committee and the board on those.
Yes, Ms. Oliveris.
I would also like and thank you for that direction, but I would like to add to that they be consistent with federal investment regulations.
Okay. Well, I think, yeah, everything we do should be consistent with state and federal law. So I'm not sure.
Investment regulations are their own separate entity. So if we would consult with counsel that could look at SEC regulations to ensure that we are following everything appropriately, that would be great.
Okay. Okay. I don't see a problem with looking at
Ms.
that.
Oliveris, if you have some specific concern about a particular type of regulation, we don't have to do it now, but if you could get back to me online, that would be helpful.
Okay.
Thank you.
Well, thank you, committee members and board, for a very robust discussion. We now will move to the next item on the agenda, which is 5B. Ms. Simpson. Thank you, Ms. Dunning and Mr. Tarp and Mr. Funson, if you will hang on, because we have some additional items that may require your response. Okay, thank you.
Thank you. Thank you very much, Chair Jones and all. So item 5B provides an opportunity for the committee to revisit its decision last year on the composition of the investment committee. And board members will recall that as part of the routine self-assessment, which the board goes through, there was a recommendation that the structure of the investment committee be brought in line with the structure of the other 5 committees which the board delegates to. Specifically, this meant rather than having a committee of the whole for investment, instead moving to a committee with 9 members. The recommendation came from one of the work streams, which was established by the board president to look at the question of roles and responsibilities. There were several work streams coming out of the NACD's survey, confidential survey, and interviews with individual board members. The purpose of all of that was to identify areas for improving board governance in order to improve performance. And during the year-long process of this most recent self-assessment, there was some research published which the committee chair and board president Henry Jones referred to in his summing up after the process was complete. It came out of Boston College, which showed that, much as we might expect, those public pension funds with the best governance also were delivering the best performance. So searching for improvements in governance is something that's very important to this board, and that's why the alternate year self-assessment process is in place. The other point that I would just like to mention is that within the board's powers reserved, you're all familiar with this, the board delegates to committees and to consultants and to the chief executive officer. But at no point does this mean that the plenary authority of the board is undermined. And as is the tradition at CalPERS, all board members, the policy says, are encouraged to attend all committees and to participate, which has been, I think, the normal practice throughout and includes even today. So I'd be happy to answer any questions. And the item is before you for the committee's discussion. Thank you.
Okay, thank you, Ms. Simpson. And I also would remind the committee members and the board that we're in a cycle of board evaluation. We do this every 2 years, and we were scheduled to do it this year we're in. This past year, but we had not implemented all of the recommendations, so we decided to move it to the beginning of March, around March of next year. So we do have a process in place to evaluate previous actions that have been taken by the board, and this is one action that could come back to that committee when we evaluate not just board committee makeup, but also a number of committees. So that's on our every 2-year evaluation of ourselves. So just be aware of that as we start this discussion on this particular item. So with that, I call on the first committee member, Mr. Perez.
Sir, I think Teresa was before me.
Yeah, but she's...
Okay, all right. So the committee structure to me is very, very confusing when we're all watching or participating in it in the same fashion. I wonder what it would take to get the team to look at the effectiveness of a committee structure as opposed to it being all the items being brought to us as the board of directors or board of administration rather. And each agenda item can just be part of that. I think it would be more efficient on our end and more efficient for the team if they only had to present things once and we didn't have to report back. Individual committees didn't have to report back to the larger board and hash it out all again. So I wonder if, Mr. Jones, you can ask the team to look into that, maybe compare us to some of the other larger pension funds and see what the structure looks like.
Okay, yes, Mr. Perez, if you're okay, if this be rolled over to our next evaluation when they look at the committee structures, if they can have a picture, that'd be part of that process?
I'd rather not, sir. I'd rather look at it sooner rather than later. In addition, I think the investment committee, absolutely, the investment and pension and health should be all of us. I've asked before not to be put on that, and I appreciate you obliging that. But I attend everything because I need to learn all that stuff. And I think with all of us attending all the meetings, it just gives our broader understanding of the system as a whole.
Yeah. Well, if when we bring back the item that that we just discussed for board consideration, of course, my recommendation would be to hold that until March. But if at that time, when we bring these other items back, you want to make a motion for that, then we could certainly entertain. But I would direct that we hold it until we can have staff do some research, because it's some of the items are going to be more urgent than others. But of course, whatever you want to do is fine. But I would just suggest that you allow staff time to do the research and get the information that may be important for a decision for the full committee.
Very good, sir. In the meantime, I'll motion that the investment committee is a committee of the whole.
Okay, there's a motion. Is there a second? If you're a second, raise your hand. Okay, so I don't see a second from the committee, so the motion fails. Okay, so that was Mr. Perez. Now we can go back to Ms. Yee.
Thank you, Mr. Chair. Appreciate you placing this item on this agenda. I just wanted to remind the members, my colleagues, that while we did have discussions about the various work streams, all of those discussions happened before the situation that we find ourselves in today. Certainly with the pandemic and the recession that we are really trying to continue to be more stay on top of in terms of our duty to this fund. Yeah, I really wanted to have this discussion today because given what is happening, and certainly the privilege that I have of serving on both of our pension funds here in California, I really do see a need to think about how we can strengthen our fiduciary duty and oversight. As Mr. Perez just mentioned, the investment committee is now comprised of only 9 of us, 9 of the 13 board members. And the most pressing issue right now is the ability of CalPERS to earn a 7% return. I don't think anybody disagrees with that. And so when we look at the market volatility, the uncertain economic recovery from the pandemic, new private asset strategy, this is just, it just begs more careful oversight from all of the board members. And especially as we're preparing to start the ALM process in 2021, I do believe that all the board members need to sit on the investment committee and ensure that they have an understanding of the investment issues, since they will be required to vote on the final proposal at the board meeting. And oftentimes we don't have that full discussion at the board meeting once the committee reports out. And I appreciate Ms. Simpson's reminder about the board evaluation process that we had, and certainly the involvement of NACD in terms of helping us work through these work streams. And I remember at the July, I think it was, yeah, July 2019 offsite, there was a long discussion with the board and staff. And one of the PowerPoint presentations talked about one of the key opportunities identified was strengthening a fiduciary duty, ethics, and code of conduct culture that, 1, facilitates candid, active, and collegial engagement, and 2, protects confidentiality and builds trust, and 3, emphasizes mutual respect and relationship building. And I think this is difficult to do when not all the board members have the opportunity to make motions and to vote in investment committee. And I would say, and I would agree with Mr. Perez on this, also the Pension and Health Benefits Committee as well. The NACD process also stated another goal, and that was to strengthen fiduciary duty, which again is difficult when not all of the board members are seated on both investment and pension and health committees. So it really makes the most crucial of decisions of the fund, ones where we all don't have the ability to fully participate in them. And I'll just contrast with this, not to say we need to be identical in terms of the governance of both funds, but at CalSTRS, all the board members do sit on investment committee, and all of the board members sit on benefits and services on the benefits and services committee. The board president appoints the board member to a committee at any time upon request. And however, the board members are not allowed to ask questions or comment at a committee meeting that they do not sit on, although they may attend those meetings. But I think as we look at important items such as the CEO and CIO annual evaluation, discount rate changes, and the funding plan, they are all at CalSTRS discussed at full board meetings, so everyone has the opportunity to participate equally. And I know here at CalPERS, we discussed the CEO annual evaluation and performance and comp committee. The discount rate is discussed in the finance and administration committee before those items are sent to the board. So you can see, and just kind of the contrast with respect to and I don't think we should ever discourage anything less than robust engagement. But for those who aren't sitting on investment committee and pension and health benefits committee, there really, I think, is not an opportunity to be fully engaged on some of the most crucial issues coming before this body.
Okay. Ms. Ortega, Ortega?
Sure. Yeah, I had a question that's a clarification about this agenda item. So I was taken a little surprised by Mr. Perez's motion because I was unclear if this was an action item and whether so I just wanted to get a clarification on what type of item this is and whether the appropriate action is to refer this to have the staff bring this back as an action item if that's where the will of the committee is. So just a clarification on the process here.
Yeah, no, this is this particular item is talking to the number of members on the investment committee. Mr. Perez's comments related to all committees, be committees of the whole. And that's the motion he was making, not just related to this item. He was saying that he
But
would
this
like.
is an information item, right?
Yeah, this is an information item, exactly. But Mr. Perez.
Right, so I'm looking for a clarification on how, if the members of this committee would be interested in having an action item for discussion, either by this committee or by the board, what the appropriate mechanism is for that in the context of this item.
Yeah, you can request that, and we will be responsive to that in a future agenda item.
And perhaps, yeah, Chair Jones, perhaps we can have Mr. Jacobs comment on information items and the way that the agenda documents an action item, right? Can you talk about that now, please?
Sure. Yeah, this has been noticed as an information item, but that does not mean that action cannot be taken on it. So action could be taken on it, or you could discuss it and ask that it come back with further definition or information or delineation or whatever else you might want on it at a later time. So it's really anything that the committee would like to do at this point.
Okay. Well,
but the original idea was it was an information item. As I say, that doesn't necessitate limiting it to that.
Okay, thank you, Mr. Jacobs. I think what I think is appropriate on this topic is that the full board have the opportunity to have the conversation. It doesn't seem to me that this committee should decide whether or not the members of the investment or the pension and health benefits are expanded. It feels like this is a conversation for the full board. So I would move an item. I guess I would say I will make a motion to expand the membership of the investment and the health benefits committee to the full membership of the board for the purpose of letting the board have that conversation at the board administration meeting tomorrow.
Well,
a second.
I'm not sure that would work with respect to the governance committee, because the way that the item has been agendized is with respect to the investment committee. And so while you could move, the motion would be appropriate as the investment committee, it would not be, we would have to notice it. If you wanted to make it apply to the to the pension and health benefits committee, we'd need to notice that for a subsequent meeting.
Okay, so I will modify my motion to be only to the investment committee.
Okay, so is that second?
That's second, sir.
Second by Mr. Okay, Ms. Hopper, will you take?
Wait, more comment, please.
Oh, comments. Go ahead. Okay, wait just a minute. Comments on this particular motion. My comment section is for previous. So, Ms. Brown.
Thanks, Henry. Thanks for the scare. I just want to thank Ms. Ortega for bringing up that issue and having this this issue potentially be decided by the full board, because it does affect the board. You know, I want to remind the committee that the board was split on the number of meetings, the makeup of the investment committee, and it took several failed motions for Ms. Ortega to come up with the winning combination that actually ended up having Mr. Fechner and Mr. Rubalcaba vote no. So it was kind of interesting how that worked. But it's been problematic this entire time, because I think that we do not have real oversight, because by the time a committee acts and makes a motion, by the time it comes back to the full board, it's been decided. It's been decided, and unless you're on the committee, you cannot make a motion, you cannot make a second, and you don't have a vote. And you really are a second-class citizen. And I think it is too critical, not only for our investments, but for pension and health benefits, that every member of the board should sit on those committees, and it needs to be decided by the full board, not just by a little subsection of the board. Thank you.
Okay, Ms. Taylor?
Yeah, my comments wouldn't have been any different either way. I believe I've been here the whole time, and we had a committee of the whole for investment committee. I don't really care, but I think to say that we're not fulfilling our fiduciary duty isn't quite where that's at, because everyone sits in. No, they can't vote, but they certainly can voice their opinion. And I think the other board members who aren't on the committee have a good say, because a lot of times they change our minds. Let's be clear. I don't sit on this committee, but I feel like I have a say. No, I can't vote, but it goes to the full board so that I can do my due diligence and finish voting at that point. But the committee of 9, it's not a little committee. It's a committee of almost everybody. We're only missing 4 more folks. So I don't know what we're resolving here. We went down to the 9 just for better governance, but also we've never been a committee, or at least since I've been here, we've never been a committee of the whole for the pension health benefits, and I never knew that was a complaint before. And I think we all have had an opportunity on pension health benefits to make comments, to change people's minds. And I think our fiduciary duty is to make sure that yes, we're absolutely read in on what's going on, but that is also our duty as well. So if you don't attend because you're not on the board or on the committee, that's on you. But I think everybody attends, everybody's interested. So I think we all are fulfilling our fiduciary duty. The difference is that we don't all get to vote. We don't get to second, we don't get to vote. One way or the other, investment committee, if you guys want it to be a committee of the whole, back to committee of the whole, I'm not sure what that accomplishes, but sure. I mean, the ALM, we all have to participate. It's the board anyway. It's not just the investment committee. It's the board anyway, because that's also our educational credit. So that's the difference there. It is the whole board participates in the ALM. But it's up to you guys. I just think, I'm not sure what we're resolving for again. I don't see it as a problem. I just know that we all voted on it. We felt that it was a good governance issue, but there's my comment. I don't see the necessity to take it in front of the full board because, in my opinion, the board governance committee is the one that talks about the structure of the board committees. So I'm not sure that should go to the whole board, but it does eventually get voted on at the whole board. So it's up to you guys.
Okay, Mr. Miller?
Yeah, I worry about a couple things. One, if any time we have a split decision, we're going to come back and try to undo it and revisit it when we haven't even gone through a full cycle with this new governance approach. That worries me. When I haven't seen any evidence whatsoever that this isn't working as well or better than not having an investment committee, which is basically what we had. We had a board that, as a body of the whole, and we added, it was additive, it was adding an investment committee of 9 people who could do the work and bring things to the board. All the decisions are made by the full board. All board members can sit in on all the committees and speak just as I'm speaking when I'm not a member of this committee. That concerns me because that's not an efficient way to govern an organization. We should wait until it comes back around. The other thing is, as Teresa said, Everyone can participate, everyone can make decisions, and I think we're just creating a problem where there isn't one, because if by Ms. Brown's logic, I'm a second-class citizen on this committee, all of our committees should then be a committee of the whole, which is not sensible and is not efficient and is not good governance and does not allow you to do that extra level of consideration and depth the committee structure exists for. So that's how I feel about that.
Okay, Ms. Middleton.
All right. Thank you, Mr. Chair. We've spent an awful lot of time talking about process, and I gather that's important. I want to second some comments that Ms. Yee said. It is incredibly important that we be seen as showing full and complete oversight and as a full board responsibility. I take exception to the argument that because one can't make a motion or one cannot vote, that there's second-class citizenship or lack of ability to exercise one's fiduciary responsibility. I have seen over and over again great deference given in committee meetings to individuals who are board members who are not a member of that particular committee. All of that said, a year ago, a little over a year ago, when I was relatively new to the board, I agreed to the decision to reduce the investment committee to 9 members from a committee of the whole, based on little over a year's experience now. I'm not sure I'm going to come to the same conclusion I came to in July of last year on this issue. I'm intrigued by Mr. Perez's argument that all committees should be committees of the whole. I just don't want to rush into a decision like that. I would like to have that presented to us as options after we have had an opportunity to complete a full cycle of under this system. So I'm going to encourage that we be open to doing things differently, but also encourage that we not rush to a decision.
Thank you. Ms. Oliveris?
Sorry, I didn't have anything.
Okay, thank you. Mr. Fechner?
Thank you, Mr. Chair. I want to say that I appreciate the comments of Mr. Miller and of Ms. Middleton. I really don't have that big of a concern about the committee being a committee of the whole. But what I want to point out is to make sure we all realize that, one, we all are able to sit in at any of the meetings. Never seen any board member denied the opportunity to ask questions or speak in any committee. I also want to point out, if you look at the investment committee agenda, 85% of that agenda item is all informational item. It's not voted on anyway. So I just want to keep that in perspective. It's not like things are being hidden from people or anything else. I think that it's all there. We all have the opportunity to get the information, but whether or not it's a committee of the whole or not, I really don't have heartburn with that. Just want to make sure we're all doing this for the right reasons. Thank you.
Okay, Ms. Yee?
Thank you, Mr. Chair. I think, when I think about this issue and why I brought it forth, that it was really a reflection of, these unprecedented times that we're in, for sure. But also, I think about what our ultimate accountability is as the governing body of this system. And it's obviously to our members and beneficiaries. And I appreciate certainly the courtesy that's been extended to me today with this committee, of which I'm not a member, that everyone can participate in any committee as they so choose. And I just want to be sure that as we're venturing into obviously new strategies and being sure that as we cast our vote as a member of this board, that we are all just fully informed about what it is that we're voting on. And there is a lot of information. And I think the for me, why I choose to come to every investment committee is because I learned so much from my colleagues, and I think the interaction is really part of that learning process, and certainly gives a richness and better comprehension about just what we're trying to achieve. And I frankly respect all of you for the disciplines that you bring to this board. And we don't get to have that on the two major committees that are the bread and butter of our work to serve our members and beneficiaries. And that's what I'm asking for, just to strengthen our fiduciary duty. How can we do oversight, really, if there's not the ability just to kind of have, that kind of robust interaction? It sets up an expectation, and I agree that anybody can join any committee discussion, member or not. That when you are a member, it's a heightened responsibility, and I think it just changes the dynamic about what the expectations are from each of us as a fiduciary.
Okay. I see Ms. Taylor had to step away. She wanted to comment, so we'll pick her up when we come back. We do have a motion and a second on the floor, but I'm going to wait, and I guess we need to go ahead and listen to our public speakers, and then we will hear Ms. Taylor when she returns. Oh, there she is. Okay. Ms. Taylor?
I didn't have any comments.
Oh, you just notified you'll be back. Okay. Okay, we do have a number of people to speak on this item, I think.
Yes,
before we do that, we're going to have Ms. Dunnan, Mr. Funson, and Mr. Tarp make any comments, and then we'll go to the public, and then we'll entertain the motion in a second. Okay, Ms. Dunnan or Mr. Funson and Mr. Tarp, do you have any comments on this item? Ms. Dunnan.
From a fiduciary perspective, you can manage as prudent fiduciaries, whether you have a committee of the whole or a committee of less than the whole, because if you have a committee of less than the whole, the final decisions are made by the board. And I advise board to operate under both structures. I do think it's more common to have an investment committee be a committee of the whole than other standing committees, but I really think this is within your, it falls squarely within your good judgment as a board in terms of how you want to operate. I'm not inclined to tip the scales one way or the other as your fiduciary counsel. I think either approach is prudent.
Okay, Mr. Funson.
Yes, thank you, Mr. Chair. Having listened to the discussion, I would say that at least in our experience, obviously there are committees, there are organizations, going back to Mr. Perez's comment, that I'm not aware of any organization that does not have committees of the board. And the purpose of those committees is to expedite the work of the board. I think the discussion clearly has reflected that everyone understands that the investment committee is there solely for the purpose of gathering information and making recommendations based on an informed discussion. And so the question really, as I've seen it in other cases where there are problems, is that there hasn't been good communication between the investment committee or any committee and the board necessarily. But I'm not seeing any evidence of that. In fact, I'm hearing quite the opposite, that there is excellent communication, there is an opportunity for participation and a common understanding. I think by having both an investment committee that makes recommendations and cannot make decisions, to bring it back to the board, I think you, as a full board, then you give the opportunity for the discussion to be heard twice, and to have, for those who have an opposing opinion or a defending opinion, to be able to express that. So it would seem to me that, particularly given that you are not through a full cycle yet of this, of the new role of a downsized investment committee, that you allow at the time to see whether or not that can work, and have a very good reason as to why one might want to change that, as you had reasons, I believe, and as Ms. Simpson said at the beginning, to have good governance be the guide in terms of improving the overall performance of the organization. So it seems that in the absence of any striking incident to me that would show that it is being ineffective, I would just suggest you stay the course and go through a full cycle and reevaluate it at the appropriate time.
Okay, thank you. Mr. Talk.
Just, I think, a little bit to add here from my perspective in working with a variety of different plan sponsors. I think the answer is that there's no answer, which I admit is maybe less than helpful to some of the committee members. I work with clients who have committees of the whole. I work with clients whose investment committees are a subset of their entire board. And I can't think of a correlation between those structures and performance on that I can say with any great confidence. So I really do think it comes back to the view that the governance committee and the board has on the level of oversight and ensuring that the lines of communication flow strongly. I just echo, I think, what Mr. Funston said about where you do see challenges is when the board doesn't have access to the same level of information that the committee has, and ultimately ends up like they are working with one hand tied behind their back. And given the communication that I see in regular interactions with the investment committee, that doesn't seem to be the case here. So just a little bit of hopefully additional perspective from other plan sponsors.
Okay, thank you for that comment, those comments. Now we will go to Mr. Fox, public members who have requested to speak on this item.
Yes, Mr. President, we have, I believe, 5 speakers on 5B, the first of which is Terry Brennan, SEIU.
Good afternoon, board and chair and board. This is Terry Brennan with SEIU California. I actually wanted to talk about the last item, so I will address this one briefly. There's very little difference between the two. I think you guys made a decision. I agree with Mr. Funston's comments. Let's see it play out. There's nothing dramatically that's happened that justifies making a change. But having said that, I'm more concerned about the proposals that were brought to light about robbing civil servants of their due rights, basically making more public unfinished investigations. And in light of that, I would suggest you be very narrow, very delicate, and certainly apply those same standards to each and every board member. It's unfair to suggest that only staff would be subject to the release of unfinished, uncompleted investigations, and that not apply to those who are responsible for holding them accountable. And so for that reason, we'll be very involved and interested in seeing what comes back to the board in that manner. I wish you luck. Bye.
Thank you. Mr. Fox.
Mr. President, the next caller is Dylan Gibbons with the California Special Districts Association.
Districts Association. Can you hear me now?
Yes, we can.
Yeah. So Dylan Gibbons, Special Districts Association. As far as the membership of this committee, I don't know entirely whether or not my members have significant concerns with changing it to the full board. I think where my concern and my issues are right now are with taking informational items and making them action items kind of on the fly. And I think for me, it's a transparency issue. You have a lot of things that come on your board agendas, your committee hearing agendas, packed into 3 days. And really where I have to work with my members is focusing on those key significant issues, which are typically the action items. While we're prepared to listen to these items, it's typically we need more feedback. We need to hear the direction of the board before we can provide input on action items. And so making a quick shift from an informational item to an action item is a real challenge. And I think it goes against the transparency efforts that CalPERS has been making, and I think has been very successful in making. And so I just caution you in taking that action today. Thank you very much for your time.
Thank you. Mr. Fox?
Mr. President, the next caller is Mr. Ben Vernaza.
Managing Director. This is Ben Vernazza. I'm Managing Director of the Institute for Portfolio Diversification. We suggest that the Risk and Audit Committee be one of the members or the chair of the Investment Policy, the Investment Committee, and also should have oversight over whether or not uncompensated risk is being prudently reduced in the CalPERS investment portfolio. As you know, CalPERS governor policy is to set forth board policies consistent with fiduciary responsibilities. And your authority, as the California Constitution provides, the board shall have authority and fiduciary responsibility for the investment of monies and is charged with the sole and exclusive responsibility over the assets of the system. The Constitution also says the retirement board shall diversify the investments so as to minimize the risk of loss and to maximize the rate of return. The Uniform Prudent Investor Act is the basis for the California Constitution, and the Restatement of Trust Third is the authoritative guidance applying fiduciary law. Within the third restatement is the following decree: failure to diversify on a reasonable basis in order to reduce uncompensated risk is ordinarily a violation of both the duty of caution and the duties of care and skill. Now, there's two types of investment risk: compensated risk, which represents 1/3 of total risk and is unavoidable, and is the expectation of being compensated for making an investment in a security. It's the price of admission. It cannot be diversified away. Uncompensated risk represents 2/3 of total risk, and it's risk that can be eliminated with diversification. It is the inherent risk of concentration of investments in industries, sector groupings, and individual firms and industries that are closely price correlated. In April 2017, Stuart Frank, CPA, accredited investment fiduciary analyst, in a letter to CalPERS and to the governor, concluded it by saying, by CalPERS omitting a procedural process or plan to manage uncompensated risk, this causes every fiduciary responsible to be in breach of their fiduciary duties. Our 2016 study of 5 California county PERS and CalPERS, we estimated the CalPERS range of loss diversification alpha was between $1.2 to $3.6 billion during the year ending September 16. That's equivalent to 37 basis points to 111 basis points.
Sir, your time is up. Your time is up. Thank you for your comment. Mr. Fox, the next person.
Mr. President, the next caller is Tim Barrows with CSR.
Thank you, Kelly. Chairman Jones, members of the committee, members of the board. Boy, what a difference between 5A and 5B. I was really happy with the lively debate in 5A, and people were not throwing stones, and then along came 5B. I really support the whole board being on this particular committee of all the committees we have. One of the things that Betty Yee said that got my attention was fiduciary responsibility and developing a working relationship between the board members. I think what we saw, at least what I saw on my laptop here in my backyard, was just the opposite of that. It seems like there's a natural division between members of the board who aren't willing to have the same kind of positive debate they had in 5A over an issue of numbers for 5B. Thank you.
Okay, thank you. Mr. Fox?
Yes, Mr. President, the next caller is Mr. Larry Woodson.
Good afternoon, Larry.
Can't hear him.
Okay, stand by. Okay, Mr. Woodson.
Okay, didn't get on the first time. Larry Woodson, California State Retirees. Echoing what Mr. Barron said, we do support full membership in the investment committee. Just a couple of statements. Mr. Miller's comment that the exclusion of the 4 members currently seems to be working fine. I would counter that with for years full membership by all board members in that committee was working fine in terms of governance. Also, stressed by a couple of board members that anyone attending could comment whether they were a committee member or not, but they cannot vote, and that's important. And also, they can't introduce a motion. And so on any issues that have some differences of opinion, I think it's very important for all the members to have the opportunity to vote and to introduce motions, and then it makes the board meeting the following day go a little smoother because you don't really have to get into the same level of detail. Thank you.
Okay, thank you. Mr. Fox?
Mr. Gerling?
Yeah, I can hear you now.
Go ahead, Dr. Gerling.
Can't hear him.
Can you hear me now?
Yes, I can.
You can hear me now?
Yes.
I'm speaking for CalPERS, so our position is that the investment committee is the most critical committee of the board, and that it is important on that committee to have as much professional opinion and information as possible prior to making decisions. It's important for all members of the board to be able to vote and introduce motions for careful consideration and to meet the considerations of fiduciary responsibility. Now, you may not agree with me, but our view is that if a member of the board is not a member of that investment committee, and an issue is brought up to the entire board for consideration with a recommendation from the investment committee, it raises a barrier against that individual is not a member of the investment committee that they have to go over. They have to argue over a decision that was made by the entire investment committee. So it discourages careful consideration of unpopular points of view, which are very important oftentimes for arriving at the right decision. So I also believe that if you have the entire board
making these kinds of decisions in the investment committee, that the board meetings will move more smoothly because there's an agreement. You don't have to rehash all the information for a second time. So it seems to me it would facilitate more effective board meetings. Finally, it is very important in terms of stakeholder confidence in the decisions, and we believe that for that reason alone, it requires full board participation in the investment committee. So we strongly encourage you to change your policy and have the investment committee comprised of the entire board so that you get the full value, the full benefit of all points of view and the professional experience of all members of the board. Thank you.
Okay, thank you. Mr. Fox?
Yes, Mr. President, the final speaker on this item is Kathy Jepson.
Thank you.
Can you hear me?
Yes, we can.
Fine. Good afternoon. This has been a wonderful discussion, but I am going to have to agree that I think that the investment board be a committee of the whole, and I never really understood why it was changed to make it smaller. Where you want your robust discussions is in the discussion in the investment committee, and it is true that I think everybody should be able to vote, everybody should be able to make a motion, because we really have a dynamic board. I be very honest, and I never thought about the pension benefit and pension and health benefits committee also being a committee of the whole. But as a retiree, there are two things that are very important to me, as I'm sure that is to other retirees, and that is that we do everything possible to get the rate of return that we need, and in the pension and health benefits, because as you get older, the benefits become more and more important. So I would urge you to make the committee as a whole for both the investment and pension and health benefits. And I think that if I happen to really like how CalPERS does things, and I don't think they have ever not had this as a committee of the whole. Thank you very much.
Thank you. Mr. Fox?
Mr. President, that concludes public comment on item 5B.
Okay, thank you, Mr. Fox. Okay, so we have a motion by Ms. Ortega and second by Mr. Perez to return the investment committee to a committee of the whole. So with that motion, Ms. Hopper, please call the roll.
Rob Fechner.
Aye.
Frank Ruffino for Fiona Ma.
Aye.
Lisa Middleton.
Aye.
Stacey Oliveris.
Aye.
Elena Ortega.
Aye.
Jason Perez.
Aye.
Mr. Chair, I have Elena Ortega making the motion, Jason Perez seconding it, and I have motion being to turn investment committee to a committee of the whole.
Okay, thank you, Ms. Hopper. And so this will move forward to the full board tomorrow as a recommendation from the Board Governance Committee. And at this time, I think we need to take a break. So let's, what is that? Return at, what about 4:30? Okay, we'll reconvene at 4:30.